Kate Brady, and I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America. I'd like to welcome you to the webinar, and this webinar is going to discuss lawful permanent residence through consular processing. So I'm going to walk you through the nuts and bolts of consular processing for an immigrant visa. We're going to talk a little bit about how that intersects with CLCMA, and then I'm going to give you a little bit of insight and a peek behind the curtain at what our organization does. So lawful permanent resident, or what sometimes people call a green card or an LPR, is permission to reside and work in the United States long term. There's many different avenues where you can come into the United States, whether it be through your relatives, through employment, through the diversity visa, or through these special programs like for Amerasians, for widows of U.S. citizens, and for special immigrants such as a VAWA, an unaccompanied minor, or maybe individuals who helped the U.S. military. You can also make that application as an investor under the EB-5 entrepreneurial program, although that is a very high threshold. That is the minimum that you can have, which is $900,000. You can get a little more information at the uscis.gov site there. To start off the process, you are going to make an application to USCIS. This application, on the top of it, you will see it as a petition, as an immigrant visa petition. That is what I call your ticket in line. Each applicant for lawful permanent residence in all the categories will start off with this application. This is one where you are going to give an opportunity for USCIS to see how you relate to the applicant or the employer, or how you qualify. So it is going to have some supporting documentation, and it does go to USCIS with a fee. USCIS will then make a decision on the application, but first it will set a priority date for you, and that is the date that they receive it. That date is very important because there's an annual limit to the visas. As you can see, only 226,000 family-based visas annually, 140,000 employment-based visas annually for the entire world across all the categories other than for an immediate relative. That means that there are some countries that are very high immigrating, and they are going to be what we refer to as oversubscribed. You can kind of see in the chart that I have here at the bottom, there's some countries broken out: China, India, Mexico, and the Philippines. That's an example of countries that are oversubscribed, because the entire rest of the world is listed in all chargeability. And then there's some dates and there's some categories down the left side. That is going to tell you when your visa application priority date is current. As you can see in the F2A, which is the spouse or child under 21 and unmarried of a lawful permanent resident, those say C, because that category is available immediately. Another category that I've referred to is an immediate relative. Those are unlimited. They do not get counted against those annual limits. And that would be a U.S. citizen who has a foreign spouse, a child under 21, or their own parent, and they are asking for them to immigrate to the United States. This visa bulletin is published by the Department of State every single month to tell you what it is on the first of the next month on where the place is in line. Sometimes it moves very quickly and sometimes it moves very slowly, and it's something that people who are in those categories that are limited must watch in order to know how long it's going to take. Sometimes it's weeks, sometimes it's years, sometimes it's decades in some of those categories. If you can look down there, there's some categories there where it's in 1997, 99, 96, and 2000. So some of those will have to wait quite a while before they're available. Once USCIS makes that determination on your I-130, the Department of State, who controls that visa bulletin, it's going to be forwarded to the National Visa Center, which is a sub-department of the Department of State. They're going to have you fill out another application, which is a DS-260, so Department of State 260 at that website. You'll get all these instructions from them, and they will take some more fees and ask you to submit some more documents, generally electronically, but sometimes physically. And once they're satisfied, that is what will make it so that they can contact the consulate or embassy abroad and schedule your interview. There is no set time frame, and until they are satisfied, you will not get that interview. And until your visa number is almost current, you will not hear from them on this part of the application. They will not take the application or the fees ahead of time. But immediate relatives or somebody like the F2A category who are current would get this pretty soon after their I-130 is approved, or if they're in another category, like an employment-based the same thing. There are also visa bulletins to deal with that. The interview process at the consulate differs by country and by consulate, but each of them will require you to show that you do not have a criminal history, either by a biometrics appointment or the application center, where they will take your fingerprints and your photo, which we refer to as your biometrics, and they will often also require that you submit a police clearance certificate for anywhere you've lived more than 6 months past your 16th birthday. Each applicant will also be subject to a medical exam, and the importance of the medical exam is not only to show you have your immunizations that are required in the United States, but also that you do not have any communicable diseases, any mental health issues, or any drug or substance abuse issues. At that interview, the consulate should have all the information that the National Visa Center had. It should have been sent electronically, but it is always a good recommendation that you take originals of those documents with you to the consulate, especially things like your marriage certificate, if that applies. Definitely your passport has to be with you. That's one of the standard documents. Maybe your birth certificate, those documents where they can actually make a comparison between what they received electronically and what you have as a physical document, so that they can see that it is accurate as a copy, because that was a copy you provided. Only the applicant will be allowed in the consulate for that interview, unless it's for a minor child or somebody who has a physical disability who needs that assistance. You will be interviewed by a consular officer, and that interview will take place over just maybe a few minutes, and they will go over your application and the data that's in it and ask you a few questions so that they can make that determination. The countries have one designated location per country, so even though you may live in one part of the country and there's a close embassy or consulate, that may not be the one that is designated. And there are some applicants who might want to be interviewed in a country where they live and not their nationality, and that's fine as long as they've lived in that country for at least 6 months. They're in the jurisdiction of that consulate and can ask for that consulate to be the one that interviews them. Some countries don't even have a working consulate, and the example I have here is Iran. They are actually not able to be interviewed in their own country. They will always be interviewed in a third country if they don't have one in their own country, and here it's designated to be in Ankara, Turkey. They do not get to choose any consulate. No one gets to choose just any consulate in the world. You go to the one that you are in the jurisdiction. So once you have that interview, what are some of the possible outcomes? The best outcome, that you're granted and you're given a passport stamp in order to enter the United States as a lawful permanent resident. That's what we all want to hear, and that is what we all hope to hear. That's very fact specific, and obviously many people do get their cases approved without much of a problem, but it is not everybody's experience. Right now it's a little bit harder because all the consulates and embassies are closed, and many different countries have shut down their immigrant visa units for several months now, and you can see some of our other webinars about those restrictions and the travel ban that might also be part of somebody's immigrant visa application if they are subject to that because of the country they're from. Administrative processing is one of those things that no applicant wants to hear. If you want to hear granted, administrative processing or a 221G or even a denial is something that you do not want to hear. Both administrative processing and the 221G are not denials themselves, but they're frustrating because they have no time frame and you're allowed to give more information, but it's really up to the consulate on how quickly they process that. They could also make a recommendation to revoke your petition and return it to USCIS. Most often this is on the basis of thinking that there is fraud or a misrepresentation in something such as a marriage-based case. There will be an opportunity once USCIS does have it that they will issue a notice of intent to revoke, and you can make some additional documents and legal arguments back to USCIS to show why it is not fraud. There is, again, no time frame, so sometimes it takes several years to come from the consulate back into USCIS's hands, and at that point there is no way to get your immigrant visa issued or have another interview. So this visa we keep talking about, it's an actual stamp in a page of your passport, and I'm sure many of you have seen that because you've traveled here from foreign countries prior to being in the US, maybe as a lawful permanent resident or as a citizen, and everybody has to get this unless you're from a country like Canada where you're not allowed to do it, or maybe you're from a visa waiver country where you can enter for 90 days without it. But the visa looks like this is a made-up visa that says, you know, happy person traveler, but this is what it looks like. It's valid for 6 months. In this case, it's for an immediate relative as an immigrant visa. So that 6 months allows them to come to the United States during that time period and to come into the United States and show it at the port of entry or the pre-flight inspection or the land border crossing. And it's really opportunity to knock at the door, to request permission. It is not a guaranteed entry into the United States. And some visas in other categories are issued for much longer times. This one happens to be issued, as this example, for 6 months. I've also seen them be issued for 4 months, but usually in an immigrant visa context, not longer than that. This is not your permission to stay. If you're in other categories, you would receive an arrival departure card. In an immigrant category, you would often receive this type of stamp in your passport that shows that you have been inspected and admitted, and it usually gives you a validity of 1 year, and it shows that you've been admitted as a lawful permanent resident. So once you've left the consulate and you know you're approved, and they're going to give you back your passport with that stamp in it, what are the next steps? You're actually going to get a packet. This packet is sealed, and you should not open this packet. It's a packet you're going to provide to the Customs and Border Protection Officer or at the pre-flight inspection, and they're going to open that and make sure that everything is in order, and then they will allow you to get onto the plane if you're pre-flight, or they will be inspecting you at the Customs and Border Protection in the US at the port of entry. If they do admit you, you will get that stamp that shows that you are a lawful permanent resident and that you can live and work permanently in the United States, although there are ways that you can lose your permanent resident status. The next step, though, is really important because you do want that resident card, not just that stamp in your passport. So USCIS, they get it on the game one more time, and they're going to process your immigrant visa packet and produce that actual card. So they have a bit more of a fee, $220, and they're going to have you do that online to get that card. And they really prefer that you do that online after you've received that visa packet, but before you depart for the United States. Because if you don't, that card is not going to get produced. You're still a resident, but you just don't have that evidence other than that 1 year stamp that you received in your passport. Once you're in the US and living here, there's some rules that you do have to follow about how long you can be outside the US, and if you're going to be out longer, what should you do? So if you need to travel for more than 6 months, and definitely if it's more than 1 year, you need to apply for a reentry permit. It's the same looking document as the ones that we've talked about in other webinars for the asylum status and for the refugee status under their travel permission. This one, though, is actually for you to be out of the United States without abandoning your residence. It does not preserve your continuous physical residence for the citizenship purposes, but it does allow you, if you still have that valid green card, to come back into the US after having been gone for more than 6 months. And it does need to be done before leaving the United States. If you're coming to the US and you get to the port of entry or pre-flight inspection and you have a different address that you intend to come to than what you gave the CBP officer, or than what you gave the consular officer, you need to give that new address to the CBP officer. And once you come into the US, the whole time you're a lawful permanent resident, every time you move, and it says within 10 days, you need to tell USCIS that you've moved by the AR11. And the best way to do that is they're online. You can call, but the best way to do it is online. When you come into the US, you want to make sure that you update your address with the US Postal Service because it is a secure document when you get your card. Sometimes the post office will not deliver it unless they know that you are at that resident. And you have to do that by going to the post office yourself and telling them that that's your address. So I'm going to go through a couple more frequently asked questions now. And these frequently asked questions are ones that in some ways might intersect with what we do here at CLCMA. There are some webinars that are going to give you some information too. Citizenship. Everybody wants to know, what do I do next after I'm a lawful permanent resident? How long do I have to wait until I become a citizen? We do have another webinar on that. Also, you must be physically present in the US without leaving for more than 180 days consecutively, as we talked about that travel document. As we talked about with the travel document, you can leave, but you need to get advance permission to leave for longer. Otherwise, you risk abandoning your lawful permanent residence for that travel, and there are other ways, such as crimes, or if they want to say that there was fraud in your residence application, you can lose your permanent residence. It's not something that is forever and ever if you do things that are not in compliance with US laws. The government can challenge your first grant of residence, and that could be on misrepresentations that were made or changes in the law that they think that now apply to you and that you did not make the correct answers on your application according to the facts. They could actually go back and challenge that. It's not very common, but in this administration, it definitely has become more common. And you are subject to deportation if you have crimes or immigration fraud. As a lawful permanent resident, you are limited in the people you can sponsor for their own immigration to come, and that would be your own spouse and your unmarried children under 21. You cannot sponsor your parents or your siblings. So now I'm going to talk a little bit about CLCMA and what we do and how that intersects with general immigration. General immigration is very broad, it's very complex, and it deals with things like this with the I-130, with consular processing, with citizenship, with deportation, and maybe asylum. Those kind of applications that are general in their nature are what a lot of immigration attorneys do. But here at CLCMA, we do impact litigation. But during impact litigation, we still need to understand what those immigration laws are. So our impact litigation covers immigration, civil litigation, and criminal. And in those areas, we're looking at civil rights and constitutional right violations, generally on the account of your race, your nationality, or your religion. And a lot of times it has to do with national security. That is something that is our niche, and that is where we focus our impact litigation. So most of those attorneys that do those other types of general immigration cases will not litigate cases. Immigration litigation and any litigation in the federal court system is time consuming, and people understand that, so they decide that they're going to only focus on those petition-based cases and not try to spread themselves out too thin. What that means is we do receive a lot of our inquiries, and we can't take every case. So I'm going to give you a little bit of an idea of how that works. So we receive hundreds of inquiries a year, and in the immigration section, you're going to receive an initial consultation where we're going to talk about your case, and then I will make a recommendation one way or another about your case. If we're recommending to take your case on as a legal service, that still needs to go through our board for approval, and if they decide that you're one of our candidates for impact litigation, they will approve it and you will become an impact litigation case for us. But as I said, we do very specific cases. We are fighting discrimination and injustice by the US government. And we are trying to identify those cases where there has been either a constitutional or a civil rights violation. And many of those are based on those complex facts that involve national security. So we accept fewer cases, but we vigorously defend the cases that we have, because we know that individual cases can make a broad impact. We do not choose cases that are going to be multiple applicants or plaintiffs for a benefit in order to make a big case. We choose individuals who, when we win their case, other individuals following them can use that and benefit from it. And that is what we consider impact litigation. So if you are a general immigration case and you come to us, you might be wondering, do I even need an attorney? Isn't it just filling out forms? Other people do it without an attorney, and it costs a whole lot. And of course, my case is simple, but I can tell you our immigration impact litigation cases came from those simple cases where they turned out not to be simple. The government either had facts that were true that they turned against the applicant, or facts that they thought the applicant was misrepresenting. And those are the types of cases that we look at. And as I said, and it's going to be discrimination on the basis of race, nationality, or religion, and it's going to be usually under national security. So you can think of those things like maybe a person was in the Army and they were granted a benefit such as lawful permanent residence because they married a US citizen, or maybe they've even applied for lawful permanent residence, and the government is going to say, we don't want you here because now we say that that country whose army you are in is one that is disfavored, and we believe that they are maybe supporting a terror organization. So if we can't have you be one of our impact litigation cases, I still don't want you to leave away empty-handed. So I will try to provide you with some resources, some very specific ones that go to your area. And these are some of the general ones that we would talk about. These would also be given to you in a more specific way. But I would like to thank you for coming here for this webinar. We do have many more webinars in our series, including ones in immigration and civil litigation, the nonprofit practice group, who we also have that is one of our non-litigating groups. And we would really appreciate you coming and viewing these. And if you have any other questions, to let us know. Again, my name is Kate Brady. If you have other questions or think that you might be one of our impact litigation candidates, please look at our website at www.clcma.org and submit an inquiry. Thank you.